Members of the United States Supreme Court will be meeting in chambers on Thursday, June 22nd, 2023, to decide if they will be accepting a challenge regarding the Second Amendment. What's the challenge? What are we talking about? And why does this apply to probably you and many other people that you know? Guys, let's get into this. So when I tell you the topic, you may go, oh, that doesn't really apply to me, but oh, you're probably wrong. The topic involves domestic violence injunctions, and the state we're coming out of is Texas. But first, why should you care? Well, broadly speaking, the anti-gun crowd is going to be using the tactics of, sure, going after the guns. We're going to try to classify a whole bunch of things as accessories or accoutrements when it comes to so-called high capacity, i.e. normal capacity magazines. But we're also going to be trying to expand as many groups of individuals as possible to be barred and not part of the people when it comes to the rights of the people to keep and bear arms shall not be infringed, i.e. a full frontal assault in the Second Amendment. So even if you may not either have a domestic abuse injunction against you or plan on having a domestic abuse injunction against you, it doesn't change the fact that rulings concerning the definition of who the people are apply to all of us as the people. Let's quickly get into the case. I'll power through the facts and we'll get to the analysis. So the case is coming out of Texas, and I'm going to tell you right now, you're not going to like the guy. I don't really like the guy if most of what is saying about him is true, or even part of what is saying about him is true. But as the Fifth Circuit Court of Appeals pointed out, this is not a case about whether or not public policy is right or wrong. This is a case involving the Constitution. The case we're talking about here is Mr. Zaki Rahimi, an alleged Texas drug dealer who had what appears to be a qualifying domestic abuse injunction against him, i.e. a restraining order. So just by way of background, the incident that sparked the injunction involved allegations that Mr. Rahimi knocked a woman to the ground, dragged her into his car, pushed her inside, and in the process of all that, knocked her head into the dashboard. He then is accused of firing a shot after noticing that a witness was inconveniently loitering nearby. So the injunction comes into play and that gets slapped on him. Subsequent to that, it seems like Mr. Rahimi was accused of being involved in a series of shootings, including one incident in which he allegedly fired bullets into a house using an AR-15 rifle. For all this, Mr. Rahimi was arrested and charged related to the domestic incident in state court against what sounds like possibly multiple different women. However, and this is where the Second Amendment issues come into play, he was also charged and prosecuted federally for being in possession of a firearm while having the domestic abuse restraining order against him. The Supreme Court of the United States, of course, then wound up issuing the Bruen decision back in June of 2022, and he was actually convicted prior to that. Well, long story short, I don't want to bore you on the procedural technicalities of the case, though they are kind of interesting, but I've covered them in a video before, so be sure to check out the description box for that. He wound up basically getting his case reheard on appeal, saying, look, Bruen decision is this part of the nation's historical tradition of firearm regulation and firearm laws, barring individuals who have a domestic abuse injunction against him from possessing firearms, and the court said, you're right. It's not. Of course, the Biden administration officials, and this including Solicitor General Elizabeth Prelogar, apologies if I'm mispronouncing that name, called the Fifth Circuit decision profoundly mistaken and went on to comment that it, quote, threatens grave harms for victims of domestic violence, end quote. So the Justice Department, that's the Biden administration, their argument for basically why this should be upheld is, broadly speaking, English and American laws providing for the disarmament of dangerous people are part of our tradition. They went on to cite that English and American going armed laws have been on the books for some time. And they also pointed to colonial and early states' surety laws. If you want to know more about those things, let me know in the comment field below. However, the opinion coming out of the Fifth Circuit stated that the historical laws disarming, quote, dangerous classes of people were not similar to the modern law here because, quote, the purposes of these dangerousness laws was the preservation of political and social order, not the protection of an identified person from the specific threat posed by another. End quote. The court actually wound up revising their opinion after it was released, perhaps subject to a lot of the flack that they're getting. And they actually included in the revised one something that definitely hits home to myself as owning the largest criminal defense firm in my state of Wisconsin. One of the judges, Judge James Ho, noted, quote, civil protective orders are too often misused as a tactical device in divorce proceedings and issued without any actual threat of danger, end quote. Guys, look, there's a lot of folks who, for very good reasons, get these protective orders against some sketchy and downright dangerous people. But I'm also telling you, the way that many courts unfortunately issue these orders, if the petitioner, that's the person seeking to get the injunction, if they go into court and if they say the right words, you now have the defensive practice of law hits the bench. You've heard the defensive practice of medicine, right? We're going to test everyone because I don't want to catch the 0.00001% chance something could be wrong. So I'll order the $3,000 MRI or CT or whatever the case may be. Right. The defensive practice of law would be that judge who's hearing the case saying, you know what, if this guy goes out and does something, I don't want to be the one blamed for this. Moreover, maybe I also want to protect that individual, but let's, be honest. They're often thinking about, I don't want to be the one blamed for this. Therefore, whatever, I'll just issue the injunction, make it 4 years and move on. I.e., in practice, if the petitioner says the magic words, sometimes with many judges, there's not much as a respondent or respondent's attorney you can do to basically push back on that. The best thing that can happen, maybe if the facts support it, is you can get basically a mutual injunction back on the petitioner. And if that person doesn't care about Second Amendment rights, what have you really gained in all that? So I think that it's really critical here that Judge Ho actually takes prudent and pragmatic view on how these things often go down in real life courts. And of course, the court got to further analysis. Before I get there, guys, if you're enjoying this video, let both myself and the algorithm know by clicking like, commenting your thoughts below. Yes, I do take the time. And if you see responses, that's me responding to you. And of course, to make sure you don't miss any of our future content, don't forget about, of course, subscribing. There's also a members section if you want to gain exclusive add-ons and features while supporting this project and channel. Would tremendously appreciate it, though, of course, we just enjoy having you here. And lastly, be sure to stick around for a quote of the day. Something that's been tremendously popular in our community tab is I always post a quote of a day, or nearly every single day. And I'm going to be integrating that into the videos. It'll be at the very end, so stick around for that. Second Amendment, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, and of course, the landmark decision in 2008, this U.S. Supreme Court noted that Heller, that's the decision name, explained that the words, quote, the people in the Second Amendment have been interpreted throughout the Constitution to unambiguously refer to all members of the political community, not an unspecified subset. That's from the case at page 580. Further, the people being refer to a class of persons who are part of the national community or who have otherwise developed sufficient connection with this country to be considered part of that community. So again, the big issue here is who's considered to be part of the people in this sort of case. And if you are part of the people, then you're going to be protected by the Bruen test, saying that all firearm laws going into you, again, we now have to be covered by historical tradition, historical regulation, that kind of stuff, right? And if you're not part of the people, well, then basically the Second Amendment does not apply to you. It's a little bit more nuanced than this, but this is going to be the gist to it. This is going to be the center of the attack against you. Likewise, same thing for the items. We're seeing this over and over and over again. Check out our video in the description box below if you want to see the gun grabber playbook that we're seeing pull out in courts all across the United States of basically saying that it's us, it's you, it's the people who bear the burden of proof of showing that whatever particular device or firearm we're dealing with, whether it's an AR-15 or a normal capacity magazine, they're arguing that that is not protected by the Second Amendment because, among other reasons, it didn't exist back at the time of the founding. So the U.S. Supreme Court's meeting to decide, some of the members, whether or not they're going to be taking this case on June 23rd. We will hope to get the white smoke to clarify whether or not they're going to be actually taking this up in the days and weeks to follow. Obviously, we will keep you updated. Now to your quote of the day. Know how to listen, and you will profit even from those who talk badly. That's from Plutarch. Guys, we will see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.